from a business perspective, these are all competitors of mine, right? I mean, if you think about it, right, you're a competitor of mine, so to speak, right? I mean, but none of us view it that way. None of us view it that way. If someone calls me, even in my own space, in my own backyard, and says, I have a case, can I have a copy of your complaint, your written discovery, whatever it may be, so I can take a look as a sample, I don't even blink an eye. I want to help them because I know at the other end of that, there's a survivor who deserves that.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, RVA Trial Lawyers, and today we've got Guy D'Andrea. Guy and I first met, I'm not great at math, but probably a decade or more ago. No, more than that, because I interned at the Philly DA's office. I think it was my second year of law school, so that would have been summer of 2013. And Guy was a prosecutor then, and I actually remember that our intern class, Guy, we actually went and saw you prosecute a case. So, and then come full circle, I started doing plaintiff's work. You at some point made the switch, and then I meet you randomly in DC at, what was it, the National Crime Victim Bar Association. Yeah, they're not the annual conference, but the one that they do in April. And
the mid-year conference.
That's right. Yeah. So I recognized you and was excited to see you, and have followed you since, and have kind of been getting a little bit into the work that you're doing now, which I'm sure we're going to talk about. But anyways, super excited to have you. And I know we've got a ton to talk about, but if you wouldn't mind, go ahead, introduce yourself to our listeners before we get started.
Sure. Well, first of all, thank you for having me. Very happy to be here. So as you said, my name's Guy D'Andrea. I've been practicing law for, I want to say, nearly 18 years now. I was, as you indicated, I was a Philadelphia assistant district attorney for just about 9 years, almost 9 years, the last 5 of which I was assigned to the homicide unit. And since that time, I'm now in the civil side of the world, where I'm the co-managing partner of Laffey, Lucy, D'Andrea, Reich, and Ryan. And the side of the firm that I am on exclusively represents, in the civil world, survivors, children, women, and men of sexual violence, physical violence, bullying, hazing, and sort of all those types of cases that involve survivors and victims of those type of abuses and harms against the institutions that have allowed these type of atrocities to occur, and oftentimes, as you know, for decades.
Well, we've got a lot to talk about. And actually, I just got a call, what was it, last night or the night before, about a bullying case that led to a suicide of a minor at a school. And we're talking about it now. I mean, it's definitely a case that if I'm able to, I want to assist with as co-counsel, but that's something that at some point I might need to give you a call about.
I'll tell you, I had one so sad 11-year-old boy who hung himself in Philadelphia school after being insistently and nonstop bullied. Resolved that case for the family. It was a devastating case about 14 months ago. I mean, I have a lot of bullying cases, but one directly on point for what you just said.
One thing that I've always said, and is that the work that we do now, the civil plaintiffs work representing victims, right? It's prosecution. It's just, instead of putting people in jail, you're able to actually help give the victim something. And it's the second best thing, which is money, right? That's all we have. And so it's not surprising to me that prosecutors make that shift into this line of work. Can you share with us kind of like, what was your journey going from spending a number of years prosecuting to ultimately getting to this line of work?
It was a very, you're absolutely right. I mean, it was a very difficult decision, at least in the time, to make, because I loved being a prosecutor. I mean, it was so invigorating. I loved standing up for those families who lost someone so tragically, or for a survivor who lived, if it was a sexual assault or other horrific type of act of violence committed against them. And I was in the heart of it. What I really thought and believed was the best form of justice for this individual was locking up the person who was a serious crime, locking that person up and keeping this individual safe, or protecting the society from this person. And I thought that was the best thing you could do for a victim survivor or their family. And then when I was looking to transition or potentially leave because I just thought it was time in my life and my career, I'm like, well, what am I going to go do? I'm not going to say names of laws that I didn't want to do, but I don't know that it would excite me or give me passionate. And then when I found this as a space that I could operate in, to your point, I am now a prosecutor, but on the civil side. And what I see now, which I'll be candid, I never would have viewed it this way when I was a prosecutor, but compensating, and it's not all about money, but in some ways, like, you are tangibly changing these survivors, or at least helping these survivors in their lives, whether it's providing housing, the necessary medical treatment that they need, whether it's inpatient or outpatient, being able to provide actual resources for the survivor versus, okay, your rapist is locked up, see you later, right? And I know that's blunt and flippant, but that's almost, when you, in retrospect now, I'm like, that's kind of what it was like. And still, look, that form of justice is so important, right? Because you have to protect the society. But I feel like it does in many ways little for the individual survivor, if that makes sense.
It does. And also taking it, I think pushing it one step further, which I know you can talk about, it does, there's more deterrence when it comes to the organizational level too, right? Because now you're looking at the responsible organization that permitted this type of conduct or created the environment that allowed for this type of conduct. One phrase that I heard a few years ago is that verdicts are to deter conduct and damages are just, the money is just the means to do so, right? And so I'm wondering if, I mean, that's the most empowering thing that I think I have found as a plaintiff's attorney, is the working up the chain, right? You have the event, you then look and you find the systemic failure that led to the event. And that often, the hope is that that singular client in their case, right, can lead to change. So it makes it safer for everyone.
No doubt. And when you look at, take a very common example, and I know people think that they get beat up on too much, but they certainly don't given the conduct. And I'm also one, meaning a Catholic, right? So you take the Catholics, and from a prosecutorial level, as you should, if you're a prosecutor, prosecute the individual priest. But if you don't go after the actual individual diocese or the overall organization, there is no motive to change. Now, what the motive should have been, right, was the protection and safety of children. But sadly, as you know, these institutions, the Catholics being one of them, for the longest time, for over 100 years, just didn't care. And we see it every day, all day, not just with religious organizations, but all sorts of organizations. What motivates them to change, sadly, is the money they're losing in litigation and the reputational harm that's coming as a result of these cases. Is that a good reason to change? Heck no. But it's still change, and it's the right type of change. So it might be for the wrong reason, but our lawsuits and what we are able to do is accomplishing so many things, including shutting some of these organizations down. For instance, I'm involved in a juvenile detention center case in Pennsylvania that, thank goodness, is completely shut down because of the atrocities. And if you can't get the organization shut down, it's at some point, ideally sooner than later, you're going to get system-wide and systematic changes to the safety protocols, policies that are in place to protect all future, right, potential victim survivors. And that type of change, which you would never get as a prosecutor, but that type of change, because it's a different system, is really, at the end of the day, so empowering and impactful for your individual client who's an individual survivor of sexual or physical violence.
And this stuff happens, right? And that's the thing that I think has blown my mind. I remember I did the Temple LLM a while back, and I forgot the lady's name, but she was on the Cosby case. But anyway,
Kristen Fedden.
That's right. And I remember speaking with her and asking her what she did, and she talked about this line of work. And I was like, well, how many cases do you have? And she said hundreds, like her section. Hundreds. And it still blows. I mean, I've got a handful. I've got a few myself, but I mean, there are people like yourself and your firm who this is all you do. Like, it's amazing to me that this stuff happens.
No doubt. And I know Kristen well. It's actually funny you mentioned her. So she tried the Cosby case with one of my law partners. So the Ryan and the Laffy-Bussey, DeAndrea Reich and Ryan, Stu Ryan was also one of the lead prosecutors with Kristen on the Cosby case. And yeah, so he's another member of our firm, a named partner who handles the crime victim cases. And between his team, my team, and all the amazing lawyers and support staff that we have here, we have a combined over 400 cases, literally 400 cases.
That's insane. I mean, it's
It
hard
is
to
insane.
fathom that this conduct happens, right? And
Yeah.
to the extent that it does. But
I mean, the level of pervasiveness in, I mean, every industry across this country. I mean, we have over 200 cases. Stu, Alec Master, and Brenda Harkeby especially are handling a lot of our massage cases. So more often than not, a woman who is, it's usually women, not always, but it just statistically is, who are getting sexually assaulted at these massage institutions, goes as a de-stressor, as a relaxer, as whatever it may be, in a place that they're supposed to be comfortable and safe. And these are reputable, or let me say it differently, supposed to be reputable national places with a national presence, and they are being sexually assaulted, and it's happening, I mean, damn near, I say, every single day across this country. And, every institution, whether daycare centers, churches, and you name the church, they have it, sadly. And it's just everywhere all the time. And it sounds like that's an overstatement, but it's just not.
That's incredible. Well, I want to talk more about this, but I also don't want to forget the many years you did as a prosecutor. Can we talk about your time at the Philly DA? I mean, I remember my summer there, and it was wild. I mean, just what happened in those courtrooms were truly insane. And the amount of work there was, and the characters, just a really fun place to spend a few months. Would you mind sharing a little bit about, like, what did your life look like as a prosecutor in Philadelphia?
Yeah. So as a baby DA, right? So my first year or two there, you are largely in municipal court, which is you're handling felony preliminary hearings in Pennsylvania and misdemeanor non-jury trials. And so you would go to court every single day, at least when I was there, every day. There wasn't, you did not have a break. Like, there was no day off from court, at least in Philadelphia. I know some people have, weeks at a time, and then they have 2 weeks off. We were every day. And you would be given 30, and on a good day, 30 cases a day, right, to go and handle. And it was, I mean, you were more, it was more like you were trying to control wild animals, right? Meaning like a zoo, you're like a zookeeper. And I'm not talking about the people. I'm talking about, there were so many things going on that it was like pandemonium, right? You have cops being like, I need this file, I need this file. I have to go to this courtroom. I have to go over there. I can't stay. Here's my cell phone number. Wait, which case are you on? You have victim survivors coming up to you. You have defense counsel who wants an offer. You have a judge yelling at you. You have the judge, judge number 2, which is the clerk of the room, right? They're yelling at you. The stenographer's yelling at you. And you're trying to orchestrate all of this. And it was, I'll tell you what, though, I wouldn't have changed it for the world when I was in it. If you asked me to go back and do that right now, it's a young person's game. I mean, it was, I look back and I smile and laugh because it's so endearing. But anyone who's gone through that fire experience, and as a certified law clerk, you saw it, or intern, you saw it, it was pandemonium, but it was the best type of pandemonium I've ever seen. But I couldn't do it again, right? I would never change it, but I can't go back and do it again. But what you got out of that orchestrating sort of the chaos, right? You honed so many skills. You had to be laser focused, right? If you're going to put on 30 preliminary hearings, I'm going to tell you what you don't have: a whole heck of a lot of time on each prelim. So you had to make sure that with this judge, who may or may not have a very short attention span because there's so much going on, you only had so much time to put your case on, prove it up, and move on. Right, go on to the next case, get the case held for court. There was a judge who I won't name her name, but she was infamous that a DA in her courtroom, I mean, she's no longer on the bench, thank goodness, but a DA in her courtroom was allowed 3 questions. That's it. You got 3 questions. If you couldn't make your case out in 3 questions, she discharged your case. It was like that crazy, right?
For the prelim? What is that? Daytime, location, what happened? But that's 4, right? I mean...
Well, you had to try to jam pack a lot. Yeah. So how you would do it is, I would say that you get good at it, right? If it's a cop witness, you say,
Go.
I'm going to ask you
Everything.
I'd say what happened, right? And then here's what I need you to do, and don't F this up, right? You talk candidly with them. I don't know. I probably said the actual word, but it's like in your answer, you better tell me date, time, location. You better identify the defendant. You better say what the person did, honestly. You better lay it all out there, because what you're going to give me after this long recitation is potentially, I have 2 follow-up questions. That's all I get. So I need you to carry a heavy burden or a heavy load, and I need to listen pretty intently so that I had 2 follow-up questions. So, you did that. But then as you grow and you learn in that trial by fire and that sort of absolute, some bizarre form of organized chaos, you grow up, right? And now you're in felony waivers and doing maybe nonviolent or non-serious jury trials. But very quickly, I was in the sort of vertical prosecution stage where I was operating out of the East Division, which is one of our most violent sections of Philadelphia. And I was handling cases from start to finish. So prelim through jury trial, that was only 1 or 2 out of each section within the office did that. And I was that person. So any non-fatal shootings, so attempted homicides, cop shootings, things along those lines, I handled, which then ultimately led to me getting promoted to homicide, which was a whole separate beast, right? I mean, but I needed all that training and experience. I had over 50, maybe 60, maybe 70 jury trials under my belt. I think it was probably 70 something before I got to homicide. And I'm so glad I did, because I'm not going to say I knew everything about everything, but I handled everything from knowing how to present DNA evidence inside and out and talking about it in a way that made sense to jurors, knowing how you handed me a firearm, because that's about 95% of our killings in Philadelphia, sadly, are about. You hand me any firearm, even if I've never seen it before, I could dismantle it, show you how to use it, break it down, put it back together again without any tutorial, right? That's important because the jury wants to know that you know what you're talking about, right? And you need to know more than the expert. And so you knew how to do all of this so that when you get to homicide and the pressure, and let me tell you the pressure of having a mom, a dad, but more often than not, the mom staring at you who was attempting to get some form of justice from the guy who killed her baby boy, right? You can't see the mom when you're necessarily doing a direct or cross, but I'll tell you what you can do is you can feel her. You can feel her eyes sort of, not in a negative way, but burning into your back of your head, because you know that so much is riding on this, and that pressure, you better be prepared for it. Because if you lose, yes, of course, it's about potentially a murderer walking free, but the more scary thing and the more sickening thing is having to turn around and look that mom right in the eyes. And so all of that training and experience I had, it was so instrumental in me being able to be as successful as I was. And I don't say that as a brag, it's a reality, as I was in homicide. I missed those moments at all. I missed them so much because of everything it taught me and all that it meant to me to be able to do that for people in the city who, quite frankly, didn't have faith in the justice system, right? They see some little 5'4" white guy going, he's not going to give a shit about my family. And showing every family who's lost someone to gun violence that I do care, and I'm going to put my money where my mouth is, and show you that I do. And I'm going to fight tooth and nail to get you justice. And all that training sort of allowed me to be in that place and work with people who have lost someone in such a horrible way.
And it's not easy work. If I remember correctly, it seems like sometimes the prosecutor is the only one in the courtroom who's really trying to get the right thing done, which it maybe be an exaggeration, but I know witnesses, sometimes getting them to cooperate, getting them to show up can be wildly difficult. And then, of course, you've got just the docket and how crazy it is and trying to get your court dates and get everything in. So if I remember correctly, I just remember it was not an easy place to practice law by any means.
I think I say it because I had some very challenging, I was assigned with many other prosecutors, but I was assigned to challenging homicides, meaning not that they're not all challenging, but like I didn't get confession cases. I didn't get, the DNA's on the gun and there's a video of this guy shooting, right? That weren't the cases like that, right? A lot of it was circumstantial. A lot of it was eyewitness. And so to your point, I don't know. And I'll have to look and think back, but I don't think there was a single case that I put on where I didn't have to get a warrant to have one of the eyewitnesses handcuffed and brought into the courtroom through the cell, meaning I had to lock them up. Now, they're released as soon as they testify, but they would not cooperate to the point where I had to get a bench warrant for that witness and send the highway unit out to pick up not someone who did anything wrong, right? But just because they would not cooperate. And don't get me wrong, for many reasons, I understand why someone wouldn't want to come and testify in a homicide. I get it, how dangerous it is. But it was that difficult. And then you put the witness on the stand, and we call it going south. In Philadelphia, maybe they do in other jurisdictions, but going south means you put them up there and say, tell me what happened on X and Y day and at this time. I have no idea, I wasn't there. Okay, well, I have, some social media posts that you made while you were there and showing you at the party, the picnic, whatever. Nah, that's not me. Well, this is your right, meaning that they're just totally lying. So then you have to go through their statement word by word. Then the jurors have to rely upon the detectives. I mean, it wasn't straightforward like in some of the counties where it's like, that's the guy who did it. Like you didn't get those moments in Philadelphia homicide.
Yeah, that's crazy. Well, I've got a nerdy question, but when it comes to like getting the substantive evidence from like their prior statements actually in as substantive, what does that look like?
Yeah, so in Pennsylvania, it's called Brady Lively, 2 different cases by the Supreme Court. And so you have to take their statement that you went through with the detective, and then ultimately later you'll have to bring the detective in. But you give them a copy of their statement, and depending on the nature of South, because there's all different levels of South, right? Some won't acknowledge the signature is theirs at the bottom, some will, right? So let's assume, so you hand in the statement. The first thing you want to do is get them to say that that's their signature, assuming that it is, right? And once they say yes to that, I guess that's technically the easiest way to do this, because now in Pennsylvania, they've adopted their statement. So, but now you have to go line by line, question by question, line by line in their answer. And this is the question, this is the answer, right? Why did it say that? I'm not asking you whether you did or didn't. What I'm asking you is that what this says? Correct. All right. Now, you didn't say this. No. And then what you have to do is you try to corroborate or show how what they're saying does now is the lie and what they said originally was the truth. And there's many ways to do that, right? Because most people who go south will admit that most of what's in the statement is true, meaning they said it. But then the pesky little parts about who did it and what they saw, they'll say, I never said that, right? So what you need to show is the circumstances surrounding what they said is the truth, right? Or if they give a detail that only they could have known, right? So for instance, I'll give you a true real life example. I had a South witness who said, I never said anything about that defendant or seeing the shooting. And this person was interviewed an hour after the shooting. And it was a case involving multiple rounds. And he said, meaning the witness said, I know, insert defendant's name, he always carries this 45 caliber handgun. I saw it that day. He described it to a T, and that's what he used. That's what he says in the statement. Now, the significance of that, not to bore you all the details, but the significance of that is if the detectives were making that up, right? They're forcing this guy to say this. No one knew because the bullet hadn't been pulled from the body yet what caliber of bullet it was. Meaning, if the detectives had put that in the statement and forced him to say that without knowing the caliber, they would have messed the whole case up, right? So meaning, at that point in time when he gave that statement, and lo and behold, of course, the caliber of the bullet was a 45, but the only person who could have known that was that witness. So when he's now saying these detectives made this up and they made me say it, well, they didn't know the caliber. And they would never make up a caliber because it could be wrong, right? And so, that's a way. And when you really break it down and explain it to a jury and you spoon feed it to them, they get it. And then you could see it in their faces. And some of it's theater, some of it's theatrics, but they get it, right? They get it when you sort of explain it properly. So you nitpick and you pull out threads that only this person could know and corroborate how what they're saying now for the reasons we know, right? They don't want to be a rat. They don't want to get killed, whatever it may be. This is the lie. And the original statement was the truth.
Let's talk a little bit about trial work, especially in like the criminal context. So doing all that trial work for years, right? And then handling the homicide cases. What are some of the most important things that you focus on now when you're preparing to go to trial, when you're in that courtroom, based on what you've learned?
Yeah. So it's really, and I've used this in civil and criminal, but I've learned it in criminal because of all the jury trials, because of being able to interview so many people from so many walks of life, witnesses, victims, even defendants in a proffer or an interrogation, right? All across the board. It's learning to quickly and immediately adapt and change, right? So if you're saying something like you need, and if you're not good at this, I humbly suggest you do some other law, but and I mean that, like, if you're not good at reading people, I don't think this is the game or the business for you, right? So if you're live and you're watching, you're giving an opening and closing, or you're directing or crossing, and you're keeping an eye on that jury because it's so important, and you're getting the visible and verbal cues not verbal, I guess you shouldn't be getting verbal cues, but visible cues.
It happens though.
Yeah, it does happen. Yeah, I got a couple amens, which is a good thing, right? Literally. And so, okay, that's my drawer. I got this person. But if you're getting the cues that this is not resonating, or they're not buying this, or whatever it is, you got to be able to switch up, right? If you're making a point in your opening and it's clear that the jurors are bored by this, or it's not resonating, or it's not the point that they want to hear about, you have to wrap it up and move on. And I see so many people not do that. They're like, well, I already wrote my opening and I think it's perfect and I'm going to keep going. Well, okay. I mean, you're probably going to have a client or a government that you're going to lose on behalf of, right? I mean, I'm not saying that it's pure entertainment, but what I'm saying is you have to use your advocacy skills to sell the argument that's the truth to these jurors if you're seeking justice, and know how to pivot when you're doing this, right? It's a huge skill to know how to do. And when you have, not just with the jurors, the witness, right? Finding those things and ways to speak to someone to get them to open up, to get them maybe to not be so south, or tell you things that you never thought you would get out of them, right? And using little things that will get them to maybe change what they were going to do, right? And I can give you a real life example of that if you want.
Yeah, that'd be great.
And I still remember the name. It was Carmelo Ortiz, and he was a known drug dealer. He was almost like Omar from The Wire, right? Like, he was the guy, like, one man show. Like, he'd kill you just as soon as he'd look at you, right? And there was a cross shooting involving two other defendants. Shot at him when he was pulling up. They were trying to kill a rival drug dealer, right? And so he pulls up with his girlfriend and his child, and they shoot into the vehicle, right? He gets out, shoots both of them. Carmelo doesn't get shot at all. He shoots them, right? And then he's the only eyewitness to identify the shooters. And the public defenders represented him, but he was the key witness in this cross shooting, at least as it related to the other two. And I was told left and right, up and down, that he's not, when he comes out, not only is he not going to tell you that these two were the shooters, and I know you have his statement, he is going to refuse to be sworn in. Now, if he refuses to be sworn in, I can't do any of the things that I told you about earlier, meaning I'm not even allowed to show him a statement. I can't even question because he won't be sworn in. So I had a relationship with the PD, and I told her I just want to talk to him about his girlfriend, at least in the beginning, if he'll just give me this, his girlfriend and his baby. And she said, I'll tell him that, but I don't know what that's going to do. Anyway, she tells him that the guy comes out in the stand. I'm thinking this case might be over before it starts, because if he doesn't get sworn in, I can't really prove my case. He agrees to get sworn in. And then for the next 10 minutes, I asked him all about 15, 20 minutes, and the judge let me do it, about his girlfriend and his child. Was an infant, by the way. And then I just, like, a feelings question, which really doesn't have to do with the homicide, but I'm like, how did it make you feel when your baby boy almost got killed? For putting aside who did it, Carmelo, how did it make you feel? And he starts telling me, and he's getting emotional. And I'm like, is that the code of the streets? To shoot at even a rival guy? And I'm not saying you are, let's just hypothetically say it. Is that the code of the streets, to shoot at someone who's with their girlfriend and their baby? And he got viscerally upset, like a lot of expletives, and the judge let him do it. F this. No, everyone knows better. And then out of nowhere, he looks at the two guys, and those motherfuckers knew it. And so now they know he's going to tell me the story, right? I made it about, I read this guy, and look, it might have backfired, but it worked. I kind of read him, And I made it about not what these two guys did to him, but what these two guys did to his girlfriend and his baby, which is I knew was a violation of the very code that, drug dealers and gangbangers adhere to in Philadelphia, maybe in other cities as well. You don't do that. You just don't do it. Because they respect, if you want to kill me, meaning the rival drug dealer, that's part of the game. But what isn't part of the game is when my kid and my baby girl's in the area, right? That's against it. I thought, at least I had a belief, if I played on that and I pushed that I may get him to tell me what happened. And in fact, he did. And those two guys were in fact convicted of attempted murder.
It reminds me of the concept that like a trial is a living, breathing thing, right? It is not a set play. We've got a trial next week, and where we've been talking with a bunch of our witnesses, and it's like, well, what time am I going to be? Well, 2:45 is when is on my schedule, but I'll tell you what, I got no clue. I mean, that's our goal.
Your guess is as good as mine, man.
Yeah, I mean, that's our goal, but you just don't know what's going to happen. So just being open to the possibility of changing and adapting, like you said, is incredibly important. But to that point, it takes a lot of time and I think experience and confidence to get there. And it's not something that I think can be easily done without, like what you said, having those early days as a DA, trying to corral the circuits, right, of getting things done. That's where you learn. That's where you develop the sea legs. Is that fair?
That's right. That's 100% fair. And knowing that, look, what can go wrong almost will go wrong in a jury trial. And knowing that on the inside, when that happens, it might be like a wrecking ball is going off inside of your body, but it cannot show on the outside of your body, right? The jurors cannot know that you are even remotely fazed by whatever it is that's happening or going wrong.
Because it's not going wrong. If you don't make it right,
bro. This is exactly how I drew it up. I knew this was going to happen. Of course, yeah.
This was all in the plan, right? At least that's what you're hoping they think. So, So before we kind of move on, one thing that when people come to me and they say, "Hey, I want to be a trial lawyer. Like I want to do this type of work. It seems like you enjoy it, which I do, and it's good work. Like I think it's to me, it's not work. This is a ton of fun, very meaningful. You really get to help people in significant ways." But I always say, like, go be a prosecutor or go be a public defender at the state level, because for the same reasons that you mentioned, I mean, you just have to go through it, right? Like you have to spend that time gaining the confidence, getting the reps, trying things out and finding yourself in a courtroom before you have the confidence to get up there and to adapt when needed. Is that advice that you also tend to give? Which I know it's not sexy advice, because when you're graduating law school, the firm's like, "Oh, we'll offer you all this money, da 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 da."
Yeah.
But in the long run, I've found that if you are willing, and I think I stole this line from Rick Friedman, but trade money for experience early on in your career, it ultimately all pays off, right? Because you're developing a skill set that helps.
In dividends. Yeah. I mean, it's a multiplier if you put the experience in first, right? And so absolutely. So when someone says they want to be a litigator, I agree. That's ultimately the advice I'm going to give. But first question, I want to know why, right? Like, why do you want to be? I think it's the greatest profession on the planet, but why? Why do you want to be a litigator versus a tax attorney, or insert any other of the hundreds of types of things you can do as a lawyer? Depending upon the answer, I will advise or maybe discourage them doing that work. But if it sounds like the right reasons to do it and with the right temperament and passions for it, absolutely highly could not recommend more prosecutor's office or PD's office, right? You had so much sort of training grounds to learn so many skills that I don't know how you would learn. Even simple little things, even doing jury trial. I remember my first jury trial, two things so simplistic, nothing to do with the actual proving of guilt or innocence. The judge first asked, "Are you okay with doing Group A versus Group B first?" I said, in my head, I don't even know what he's talking about. What is Group A and what is Group B? I had no idea what he was talking about, right? And so you have to fake it, because you're sitting there going, I I only want to do, but I don't want to rock the boat, Your Honor. I want to do what Your Honor's normal practice is. And I'm like, I'm going to figure out what the heck this group A and group B is, right? And so you figure it out, right? But now I know what group A and group B is. The next thing was, is the Commonwealth ready? When I was prosecutor, is it ready to pass the pad? Had no idea. No, I never heard of that before, right? I'd never done a jury trial. So I was like, I believe I'm ready to pass the pad. I'm hoping I'm going to get some cue as to what the heck. And the clerk, who I happen to knew, the court crier, who was a friend of mine, like leaned in from the younger days and was like, you have to write whether you accept or strike this juror, then pass the pad to the defense. And I'm like, oh, thank you. Thank you for saying that so low so I don't look like a total rookie. But like that's so silly. But like, next jury trial, I certainly very confidently, without BSing, could say, yeah, I'm ready to pass the pad, or yes, in fact, I want to start with group A, right? And so, that's so anecdotal and silly, but all these little nuances, because there's a million of them, right, that happen in a jury trial over the years. And so you get this muscle memory and then the confidence that comes with just knowing that you are going to be in control and command of that room. And that comes with absolute experience, obviously coupled with you have to be naturally talented, in my view, as well.
That, and they're also the training. The cool thing about nowadays is like, and I say that as if I'm an old guy. I'm not. I'm still very much a young lawyer, but the amount of material out there and training opportunities, if one wants to grow, it's there. It's there.
Oh my goodness. Absolutely.
Arguably, there's too much because some of it's nonsense.
Yeah.
But
everyone's got an opinion. There's no doubt about it.
That's right. Especially in Philadelphia too, right? So,
actually lawyers. Yeah.
Oh yeah, for sure. So, and I've also noticed that and I tell people in the civil practice, yeah, if you can find yourself at a great civil firm, fantastic. But good luck getting a jury trial. I've had 2-week one this year. We've got another one next week. We've got a bunch set in the coming months. There's no guarantee that they're going to go. But if I finish this year with 3 or 4 jury trials, that's a good year, right? And
oh, it's fantastic,
right?
Sure.
And so, but if you're just starting out, you just don't get it. So anyways, I'm glad we're on the same page with that. But I tell people over and over again, if you're a young lawyer, there's nothing wrong with, and actually not just nothing wrong, it's an exceptional opportunity to go into the criminal world and get your feet wet there, because it's really, and it's important work. You're not just there for a skill set. It's fun, or it can be fun. It's difficult. It's stressful.
Sure.
It's the stuff they make movies about, right? Which, if I'm being truly candid, is one reason why I became a lawyer, because I like the drama. And
there's no doubt.
Yeah, it's fun. So let's talk a little bit more about the sex assault cases. One thing that I'm always interested in is valuation, and that sounds very technical, but it's not, right? But what is the value of a sexual assault, right? And I recognize there isn't an answer to that, right? I can make arguments that the value is priceless, right? The taking of that innocence, the taking of that that person, the part of that person's life at no fault, against their will. There is no amount of money. But then at the same time, I don't know. In your office, how do you guys go about figuring out, what to ask for?
Yeah. So I practice nationally. So luckily there are many jurisdictions, and we're where you can ask for numbers. My home state of Pennsylvania, which is a minority of jurisdictions, we cannot even remotely suggest a number.
Right.
Cannot suggest one. Right. So that even makes it more challenging.
With the exception of economics, right? You could.
I'm sorry. Yeah, of course.
But
so
that's
in
not
Pennsylvania,
a thing in your cases, though, right? Economics.
Now, what are you gonna? We call it boarding numbers, right? Boardables. What are you gonna board? You're not gonna have any boardable numbers, and if you do, you don't want to board them because
they're low.
Not that much, but okay, even if the person's been in therapy for 5 years, what's that going to be? $50,000? You don't want to put $50,000 up there because you know what you're going to get? $50,000. I don't want
$50,000 plus right? five for the inconvenience, right? Exactly.
Yeah, exactly. Right. So we don't board those. So here's how I view damages in my cases in the sexual abuse and assault world. I first focus on, and this might sound strange, and some people disagree with me, but this is my opinion. Damages, and I say this to defense attorneys, and I say it to mediators. I'm saying this very tongue in cheek. I don't care about damages, and I don't care about what my client is going to say about that. And mediators and defense attorneys are like, then I'm not exactly sure what you're doing here, right? And here's what I mean by it. And this is why I'm saying it's tongue in cheek, because obviously I care immensely and deeply about what my client is suffering from. But as it relates to from a positional standpoint and a legal argument, and well, maybe not a legal argument, but a persuasive argument to a mediator or a judge, a jury, or a defense attorney, in my view, what is going to drive damages has little to do with what the client is going to say about their therapy records, and instead is going to have everything to do about the conduct of your organization and or perpetrator, right? And so that's what drives the value. The more ways and more times I'm making the case, in an opening statement before a jury hears my client's name, they're going to have 90% of the opening is all about your defendant, your client, the organization, and what they did. So by the time you start talking about what happened to the plaintiff, it isn't an, hey, do you believe this? The jurors already say, oh my God, all these failures. It's not going to be a matter if this happens to someone. It's a matter of when. And they're already so outraged that by the time you get to talking about, of course this happened to my client, they're already ready to open the checkbook. And it had nothing to do with how much therapy the client has had, whether the client has resulted in self-medicating through drug and alcohol addiction, which we see so much of, and understandably so. None of that matters. I mean, it matters. I get it. Yes, of course it matters. But what I'm suggesting is what takes a case where I've had lawyers say, this case is worth $50,000, $75,000, and they hear, how did you get either in a settlement or otherwise over $1 million? And also, I'm going to tell you how I do it, because I didn't make the case about my client. I mean, I did, right? Understand that, of course I did. But it's making sure that you are so laser focused on how bad that actor was or how bad that organization was, that is going to incense the jurors, right? And then you couple that with the fact that it happened and what happened to the client, and of course, what happened to them in terms of their damages. And, the check almost writes itself. And I mean that. And jurors every day, I mean, they're absolutely, if you incense them as you should with the truth about the conduct, that will drive the value, right? Where defense attorneys want to focus on, your client hasn't even ever gone to therapy. I don't care. I literally don't care. I mean, I hope that they do, because I'm a strong and big believer in therapy, and I want them to get the therapy because I actually think that's going to immensely help their lives. But from a damages perspective, go to therapy, don't go to therapy, right? We'll prove our case and we'll get a big damages award. And I'm not worried about a defense argument to the contrary. I want them to go to therapy more because it's going to help them in their lives, right? And so, that's a long answer to it. That's really how I view, the damages, and how I put a valuation and how I quantify the unquantifiable.
Well, and it's consistent, frankly, from what I've learned over the last few years and the way that we practice. I mean, we have a car wreck case next week. Defense has admitted liability, but we're going to do the same thing. I mean, 90% of our case is going to be about what happened and the choices the defense has made, contrasting with what accepting real responsibility looks like. And then we get to I say this often. It's like, if damages really mattered, and that also doesn't sound great, but because they do matter, then there would be consistent. I mean, it would be like, okay, broken arm, that's worth $37,000, right? And then you'd see that consistently across the country. But it's all nonsense, because it doesn't, right? Like, there's a case in Texas a few years ago. It was a lady was killed by a cable guy who had a terrible criminal record, and the jury came back with some like 200 some million compensatory, some $1 billion punitive against the company. And certainly I don't know the reasoning. I was not in the jury room, right, during deliberations, but my guess is it wasn't just a compensatory verdict. They were ticked off that the company knew that they had someone with propensity for criminal behavior in a record proving it, and they put this guy, or allowed for the opportunity for this guy to get into this lady's house under the guise of being at work, and killed her, right? So, I mean, and there's a reason why defense wants to admit liability, right? I mean,
no doubt. And I'll tell you, like what you just described, I'd say this to every new attorney, or, when we're talking about or in mediation, they hear me say to mediators and defense attorneys, I get punitives in every single case. And they go, the hell you do? 1% of attorneys in Pennsylvania get punitives in any case. I said, I get them in every case, because what I mean by that is I don't actually get punitives in every case. I'm getting punitives before I get punitives, right? To your point, right? the compensatory damages award, if I do my job right, it's essentially punitive damages. Is that legally allowed? Who cares? Because the jury isn't saying that's what it's for, right? So juries are using the magic word as compensatory, but I'm going to tell you right now what it is. It's punitive damages.
It's how much the defendant deserved to pay, and that's punitive.
Absolutely, 100%.
I mean, and that's why there's a difference between the individual defendant and the corporate defendant, right? Like that's why, that's why there's a difference between the small mom and pop shop and the massive Ford Motor Company, which we just went up against, right? Like this is good stuff. This is really good stuff. Can we talk a little bit about the NCVBA? And because I didn't know anything about it up until a year and a half ago. And it's opened my eyes to this practice area and to all the people around the country who are doing it. And I know you're super involved on the board, right?
Yes. Yeah. So National Crime Victims Bar Association, for anyone who is doing this type of work, it is a must organization. It is a wonderful, amazing collective of some of the most talented attorneys across this country who specialize and almost exclusively or close to exclusively representing survivors of physical and sexual violence. And not only is it a wealth of knowledge and just people who share the same mission and passion and what their focus is in life and who they want to help, it's also how they help, right? So if I ask someone, from a business perspective, these are all competitors of mine, right? I mean, if you think about it, right, you're a competitor of mine, so to speak, right? I mean, but none of us view it that way. None of us view it that way. If someone calls me, even in my own space, in my own backyard, and says, I have a case, that I know you handle 50 of these already. Can I have a copy of your complaint, your written discovery, whatever it may be, so I could take a look as a sample? I don't even blink an eye. I want to help them because I know at the other end of that, there's a survivor who deserves that, who deserves, this attorney not only doing their own work in terms of crafting, the perfect arguments and things along those lines, but begging, borrowing, and stealing if there's an argument out there they didn't think about, or maybe a way to get at another defendant that they didn't think about, right? And so that level of collaboration and work and ability and willingness to share your proprietary work products. I mean, what a wonderful space. I mean, ask another group of attorneys who are competitors how often they share their proprietary work. I'm going to go out on a limb and say it's going to be real difficult to find that in another area of law.
I agree. And that's probably one of my favorite things about this practice area is the plaintiffs' lawyers who are really doing the good work for the right reasons. They have no problem sharing. No problem.
That's right.
It's a rising boat lifts, or a rising tide lifts all boats, and people truly believe it, and it's incredible. So I hope people listening really want to be plaintiffs' attorneys, but go be a criminal lawyer first, right? So
right.
That's the way to do it. Well, Guy, this has been a lot of fun, man. Thank you for jumping on.
Yeah. No, thanks for having me. I appreciate it. Yeah.
I bet if we had the time.
It goes fun when you're having fun. It goes fast when you're having fun with someone. So
it goes really fast, but we'll keep the conversation going. Guy, I'll see you in Florida. I guess, when is that? Is that in September?
September.
Right.
Yeah, September after Labor Day.
I think that's right, for the NCVBA conference. It's my first time going, so I'm very excited.
And it's amazing. It's absolutely amazing.
I saw the agenda from last year and I was like, wow, this is incredible. So a lot of good opportunities to learn and meet some cool people.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.